What this also means is that the Rome system is not just about, like I said yesterday, a Kelsonian model, which is a pyramid with the International Criminal Court at the pinnacle of this pyramid, all authority radiating from it. Rather, the international justice movement looks more like the Seattle swarming. When you think of the Seattle swarming, it's a bunch of networks, a bunch of groups that are governmental, non-governmental, individuals all participating for different reasons towards a common end, and technologies of coordination contributing to a common policy goal. This is how I think the international justice movement is going to work in the future. You're going to have human rights organizations in the Congo that are submitting evidence to the prosecutor. There's going to be state departments, there's going to be militaries, there's going to be prosecutors' offices that are all contributing towards a common goal, and that's the prosecution of individuals who have committed massive crimes. And there's going to be resistance, and there is resistance at all levels. There's resistance from people who have committed the crimes, and there's resistance from people who don't want this system implemented. But I think that eventually, whether those people like it or not, this is the system that we're now inheriting. I think also that international law is moving more from a focus on states to a focus on individuals. This is another aspect of the moment that I was speaking about earlier, and that the future is becoming apparent. That the individual focus is going to result in an era where high politics is also going to become the subject of legal scrutiny, and the classic immunities are going to be eroded. And we see this happening already. At this point, the International Criminal Court has no jurisdiction over American political and military leaders that have committed crimes in other countries. They might have, the court might have had jurisdiction if one of these states was a member of the statute, but Iraq was not a member of the statute of the International Criminal Court, and it can't proceed on that basis. And absent the Security Council referral, the International Criminal Court has no power to proceed of its own volition. So it's a matter for the future, and it's a matter for the United States to decide whether it's strategic and whether it's right to sign up to this court. We're signing up will allow them to have an influence and a say on how this international justice movement develops. Not signing up, the thing is going to develop on its own, and they may insulate their own political and military leaders for the time being. Meanwhile, the machine is moving forward. The networks are becoming thicker, and the future is out of its hands. So I think I'll end there.
Good afternoon, and thank you, Mary Ellen. Another fascinating panel at a fascinating conference. For the past 13 years, I've been co-teaching a postgraduate interdisciplinary seminar at the University of Virginia called New Thinking About War and Peace. My co-teacher is John Norton Moore, who served as chairman of the board when I was the first president of the U.S. Institute of Peace, and we got real interested in where do wars come from and what can we do to stop them. And our conclusion, among others, is that if we intend to influence the behavior of potential wrongdoers, whether they're tyrants contemplating acts of aggression or soldiers contemplating committing war crimes, we must focus on incentives. We must structure an environment in which they perceive in advance that the cost of their wrongdoing would be outweighed, but that the benefits would be outweighed by the cost. Despite the 1928 Kellogg-Briand Treaty, the world community refused to uphold the law when Japan invaded Manchuria in 1930 and Italy invaded Ethiopia in 1935. The appeasement of Hitler at Munich in 1938 persuaded him that his enemies were, quote, little worms who did not need to be taken seriously. At least 30 million people died as a result, and World War II should have taught us that international law will not contribute to the struggle for international peace unless we are willing to enforce it. In a similar vein, we're unlikely to reduce war crimes unless those inclined to commit them perceive they will be held accountable and the consequences will be unpleasant. A few days after Saddam Hussein invaded Kuwait on August 2nd, 1990, John Norton Moore and I co-authored an op-ed that originally went to the New York Times, and after the usual weeks with no response, was finally published in the International Herald Tribune in September of 1990 under the title, Apply the Rule of Law. And in addition to observing that the Security Council could require Iraq to pay reparations to those injured and place constraints on Saddam's WMD programs, we were, I am told, the very first people to suggest that Saddam be tried as a war criminal. In August 1991, when I was serving as chairman of the ABA Standing Committee on Law and National Security, I wrote and got the ABA House of Delegates to approve, for the first time in its history, a resolution calling for a war crimes trial. I was also actively involved in getting both houses of Congress to pass unopposed resolutions to the same end. So these are not new issues for me. Much of this conference is focused upon the tragic violation of international law by our own government, and that is appropriate. Those violations have done tremendous harm to our country and to our reputation around the globe. But it's important that we not let our anger obscure the reality that is so often the case. The war crimes committed by our own people are dwarfed by those of our enemies, who intentionally target civilians and often decapitate those who have the misfortune of falling into their hands. Despite my strong and long-standing support for upholding the rule of law by bringing war criminals to justice, I must admit I'm uncertain and somewhat agnostic about what to do at this point with those who have committed war crimes, the people we've been hearing about these last 2 days. In principle, I think any effort to hold wrongdoers accountable ought to start at the top. There may be some specific cases in which, if I knew the full details, I would favor prosecution of Army sergeants or CIA interrogators. But as a general principle, I'm wary of going after low-level soldiers or CIA people who have in many cases voluntarily gone into harm's way, who have acted after having been assured that the President of the United States has approved the techniques and the Attorney General has certified them as lawful. These are non-lawyers, and these are cases in a wartime setting where you're allowed to shoot the enemy in the face or in the stomach on the battlefield. And I can understand young people untrained in this area simply not understanding that what they were doing was a violation of the law. Incentives are important, and punishing individuals in such a setting may well provide a strong incentive to produce a generation of timid, risk-averse military and intelligence community personnel. In war, they know it's perfectly legal to shoot the enemy, and I'm wary of holding junior non-lawyers accountable for violations of rather technical rules and compared to the more grave examples of torture that we're all aware of from many past wars, in a setting where the Attorney General has said what we're asking you to do is lawful. Nor am I sure what to do about Bush, Cheney, Rumsfeld, and the lawyers involved in these decisions. I guess my first question is, did they know or should they have known that some of these techniques were unlawful and even war crimes? Most of my JAG friends and other experts in the law of armed conflict assure me that violations of Common Article 3 are not war crimes under international law. That seems counterintuitive to me, but I accept their judgment. But it's absolutely clear they are war crimes under Title 18, Section 2441 of the U.S. Code, the 1996 War Crimes Act. I'm not even sure how to try such people. I was on the interagency group that made a decision to walk away from the World Court in the mid-1980s over the paramilitary activities case. Indeed, I was by far the most vociferous dissenter. I almost resigned from the State Department at the time. But then when I saw the case, it was an absolutely horrid case. Just to give you one example, both the United States and El Salvador told the court in sworn affidavits that El Salvador had asked for our support. I had spoken to the president of El Salvador, President Magana, and he had said, yes, we did ask for American support. The International Court of Justice concluded they made no such request. It was, in my view, an outrageous case, and it's made me gun-shy of international tribunals. If there ever was an American war criminal, it was Lieutenant William Calley of My Lai fame. If I had been on his jury, I would have voted for the death penalty without a second thought.